you have to know going into any negotiation what your best alternative is. And that can then open the door to something that nobody's really thought of.
Good evening, everyone, and welcome to our lecture tonight on negotiations with Micheal Erdle. My name is Carrie Damon. I'm the Director of Entrepreneurship Education here at Mars Discovery District. Just wanted to welcome everybody in the audience and also everybody on the webcast. Thanks for joining us. I'd like to introduce our speaker tonight, Micheal Erdle. He's the managing partner of Deeth Williams Wall LLP and a seasoned Entrepreneurship 101 speaker. Deeth Williams Wall LLP is a leading Toronto technology and intellectual property law firm. Micheal has practiced primarily in the areas of information technology and intellectual property law for more than 20 years. He's a qualified mediator and arbitrator and is a member of the ADR Institute of Ontario and the ADR Institute of Canada. Welcome, Micheal.
Thank you very much. I'm very happy to be back here at the Entrepreneurship 101. I think I was wanted this to be the first year that it was offered, and it's grown a huge amount since then. So I'm very pleased to see everybody here, and I understand that there are a lot more on the webcast. So that's terrific. I'm going to talk about negotiation and conflict resolution tonight, and I'm going to break it into those two parts. Most of the talk is on negotiation. I imagine that that's the area that you're most interested in getting some ideas and some tips to be more effective negotiators and to deal with negotiators who are on the other side of discussions. And I will wrap up with a few minutes about conflict resolution, because in all of our lives, we're going to experience conflict. And so the more we know about how to resolve that, the better we will do. And the better we'll do in our negotiations as well. So what is negotiation? First of all, it's a process. And most negotiations involve an ongoing relationship. So it's a continuing process. And we all know that from both our personal lives and our business lives. You can also look at it as a structured conversation. And I'll talk a little bit more about that, because how you structure it is very important in determining how it's going to turn out. You can be the world's best negotiator, but if you don't come into it with the right approach and the right understanding of what you're trying to accomplish and who you're negotiating with, you won't be as successful. And it's a means to an end. It's a way to get to an agreement about something, and we shouldn't forget that is our goal. It's not about the negotiation; it's about the agreement. So we all negotiate. We negotiate all the time. We learn to negotiate about the same time as we learn to speak. And anybody who's got kids knows what good negotiators they are. Because they understand the leverage that they have, and they're not afraid to use it. Last time, my kids, my daughter, I have 3 daughters, they're all in their 20s now, so they don't have meltdowns in supermarkets anymore, but they were very good negotiators when they were small, and they're still good negotiators. And we're all good negotiators in our own way. And we do it all the time, but we do it without thinking about it. And so what I'm going to talk about today is a little bit of how to think about negotiation. And I hope that will help you to be more effective in your own negotiations. So there's really 3 bases for negotiation. One is interest, and by interest, what I'm talking about is what's really important to us, our needs and our wants, what we're trying to accomplish. The next level is rights, and that's where I come in as a lawyer often. It's about legal rights, or some other kind of rights, some moral rights, or in an organization, well, this is how we do it. And this is how we've always done it, so this is the way we have to do it. Anyone who's tried to talk to their HR department knows what that's about. And then there's power. And I mean, power is very important. It can be a very destructive way to negotiate if you're always negotiating based on power. But it's important to recognize, and sometimes it's necessary to use it. And just as an example, a current example, because I happened to hear the new Minister of Education for Ontario was just sworn in, and she was on the radio talking about what she would like to do to try to repair the problems that have been going on in education and with the teachers. And what she was saying was, first, I'm going to listen, and then we're going to talk, and it's all about the kids. And that, to me, is a way to get back to the underlying interests. Education is for the kids, it's not for the teachers, or for the parents, or for the government. It's not about us, it's about them. And so conflicts tend to escalate, and they have their own momentum. And again, in the education field and the fight between the teachers and the government, you can see how it escalated from, well, we need to do everything for the students, to, well, these are our legal rights, our bargaining rights, the school board's rights to control their employees, to power, where the teacher said, well, if you won't negotiate with us, we won't participate in extracurricular activities. And the government said, well, if we can't come to an agreement, we're going to put in legislation and take away your rights to bargain. Those are just simply power negotiation tactics. The government has the power to just simply change the law. The teachers, then, their only power is to withdraw their services, to withdraw their time and their volunteer efforts that they otherwise would actually have an interest in doing. If you go back to the underlying interests, the teachers actually want to do the extracurricular activities. The government actually wants to have a good education system. But how did they get trapped into this escalating conflict that took them from that up to, well, we're going to change the law. Well, if you change the law, we're not going to do extracurricular activities or whatever anymore. So that's how things escalate. Power strategies are pretty basic. They're unilateral. There isn't much subtlety to them. They're effective. And I'll talk some more about how we deal with power strategies. But they're adversarial. And usually it's always win-lose. But sometimes, often, it's lose-lose. Because if you have to exercise that power, you've actually lost your kind of moral authority. And if you've ever had the argument with a child who keeps saying, why, and you end up saying, because, just because, that's it. That's that kind of approach to negotiation. And it has a negative impact on future relationships. It always seems to have a negative impact. So rights, a little bit better. There you're focusing on things like contracts or policies, procedures, simply past practice. Or third-party decisions. It's when you go to an arbitrator or you go to court and somebody's going to decide who's right and who's wrong. Again, it's adversarial, win-lose, and again, it's expensive, and it doesn't do anything to help the relationship. There's usually a negative impact. Interest-based negotiation is focused on the underlying interests of both sides. It's more about dialogue and communication, about sharing information, and trying to maximize the results for everybody. And that's not always possible, and I'll come back to that, how we deal with that problem. But that's the goal. You look for ways to maximize the benefits. It's dependent on an ongoing relationship. This is the kind of approach that you can use when you know you're going to, or you expect you're going to have an ongoing relationship with the other party. A one-time event, if I go in to buy a car and negotiate with the car dealer and I don't ever expect to be back there again and negotiating with them, well, then I can just negotiate as hard as I can to get the cheapest price, and I'm happy with that. Because there doesn't have to be anything in it for them. I don't really care. But if you have an ongoing relationship, then you do care. So the goal is win-win. It's more collaborative. It focuses a bit more on the dependencies between the parties. The goal is to build trust and to have a positive impact on the future. So here's just a way of looking at power and rights and interests. The slide is very complicated, but the idea is very simple. And that is that things like negotiation and mediation, you have the most control. Everything is within your own control, how it's going to turn out, how it's going to proceed. And it's very low cost. And then as you go up that scale, the costs go up and the control goes down. So even in the middle band of rights-based decisions, like going to court or going to arbitration, once you start down that track, you've given up control. You've handed over the decision to a court and a judge. You don't have control over how it's going to turn out anymore. And it gets very expensive very quickly. And in a power-based situation, that's where you have the most cost, potentially, and the least control. And there, look at international conflict and war. War is very expensive, and once you start, you can't stop, and you're either going to win or you're going to lose. It's kill or be killed, and you've got very little control over the outcome. So very expensive in terms of risk and the outcome, and virtually no control over how it turns out. So what's the golden rule? Whoever has the gold makes the rules. De-escalation is, I think, one of the very important goals of any kind of negotiation. If you're in a situation where somebody is focused on rights or says, well, I get to decide because I've got the power and you don't, or I've got the money and you don't. And for a lot of entrepreneurs, a lot of the negotiation is about money, and whoever's got the money really has a huge amount of leverage in the negotiation. So how do you de-escalate that and bring it back down to rights and interests is the challenge. And that's what we'll talk about for some of the rest of this talk in how to negotiate. So one of the questions that I'm often asked is there a duty to negotiate in good faith? And generally, no. In terms of legal duties or legal obligations. Sometimes there is in contracts. Sometimes there is in a particular legal relationship. There's an obligation, I think, to respect the legitimate interests of other parties in legal negotiations, contracts, and those kinds of legal relationships. And the Ontario courts have said that there is. And where there's an imbalance of power, the Supreme Court of Canada says that there is a duty to negotiate in good faith. And that's in situations like employers and employees and similar situations. So there's a spectrum that applies. Lawyers and others who have what are called fiduciary obligations. They have to act in the best interest of their clients. Trustees of a trust have to act in the best interests of the beneficiaries of the trust to their own cost, if necessary. In the middle, there's a general duty of good faith, and then there's simply a duty to act honestly. You can't actively mislead or misrepresent or lie in a contract. You can't, in selling your house, lie about the condition of the house. But you don't have to give away more than necessary either. Some of those situations are buyer beware. So just simple examples of who are fiduciaries. And for those of you who are involved in startup companies, a corporate director, it's important to know if you're a director of a company, you have to act in the best interests of the company, not in your own best interest. Even if you're a shareholder of the company, as a director, you have to act in the best interests of the company. Good faith obligations, some professional codes of ethics require it. A lot of contracts say the parties will negotiate in good faith or will act in good faith. And other specific relationships like it with an employee and an employer. But generally, when you're negotiating, you can negotiate in your own best interest. You don't have to look out for the other party's interests when you're negotiating. I'm going to say that it is in your best interest to make sure that they get a good deal as well, but that's up to them. So what kinds of negotiation do we see? What kinds of negotiations are we involved in, and how do we go about doing that? One is you have to determine whether you're distributing value or you're creating value. Is the size of the pie already defined and all you're trying to figure out is how to cut it up and who gets the bigger piece? Or is there a way to make a bigger pie? If you can make a bigger pie through problem solving and creative approaches to whatever the issue is, then you're creating value and you're not just distributing it. So what does each side want and need? And be clear about the distinction between wants and needs. Wants are all of the things that we ask for and we'd like to have. But there's a bottom line that everybody has, and that's our needs. If we don't get that, we're better off to not have a deal at all. That's the point where you walk away and say, well, it's not going to do it for me. And interests, and there are different kinds of interests. So in any kind of relationship, there's common interests, there's complementary interests, and there are conflicting interests. The common interest. So back to the example of the ongoing conflict between the government and the teachers. There's a common interest in education and doing the right thing for the students. I think everybody involved on both sides can agree on that. So they do have common interests. They have complementary interests. There are things that they can do together that don't particularly benefit or hurt either of them. They're the things that don't cost them anything. And then there are obviously conflicting interests, and that's what at least on the surface, the dispute is about. But the dispute probably is more about a mismatch between what should be complementary interests, where they should be able to reach an agreement because it's in both their interest to do that. And a good example, a very simplistic example, is the situation in the restaurant kitchen, where two of the chefs, are fighting over a crate of lemons, and both of them have got their knives out, and they're going, "You can't take those. I need them." And the executive chef comes in and has to break them apart before they stab each other with their knives. What's this fight all about? And one of them says, "Well, I need the lemon juice from all of these lemons because I'm making a recipe and I need all this juice." And the other one says, "Well, I need zest for my recipe for a cake, and I'm not willing to give up the lemons because he's going to take them all and I won't have any." It's an obvious answer, right? One of you gets the juice and one of you gets the rinds from the lemons, and you're both happy. So there are common. I mean, that's an example that everybody uses. It's rarely that simple or that easy, but occasionally it is. Interests versus positions. Those are the needs and the wants. Positions in a negotiation, all of the demands that people have going into a negotiation, those are based on their wants. We have our list of demands. These are all of the things that we'd like to get, but rarely do you expect or need to get them all. So, what is the difference? What are the real underlying interests that determine what the actual needs are? Because if those aren't met, then there isn't any possibility of a deal. The other thing that you should do in negotiations is try to separate the people from the problem. We've all had to negotiate or deal with difficult people. And it's very frustrating. And sometimes it's almost impossible to deal with them, no matter what it is you're negotiating about. But if you can separate the person and the problem, you can make a lot of progress. It never hurts to be nice to the person you're negotiating against, and it usually helps. And one of the really good books on negotiation, called Getting to Yes, says is be soft on the person and hard on the problem. And so instead of saying, "Well, that's a stupid idea," you say, "Well, I have a problem with that suggestion or that approach because this, that, and the other thing." Just saying it's a stupid idea is really attacking the person. You're not saying the idea is stupid. You're saying they're stupid. I mean, at least that's what they're hearing. Consider other options. Always be open to alternatives. Look for ways out of the box that you're in a difficult negotiation if you reach an impasse. There's usually some other option. And one effective approach to do that is to try a brainstorming approach and just identify, well, what are all of the other options without trying to assess them, without evaluating them, without even criticizing them. Get them all out there. And that can then open the door to something that nobody's really thought of or not considered seriously that might actually work. Look for objective alternatives, and that's going outside. If you're talking about a salary negotiation, well, what are other people in the same position paid? What do other companies do? What are the policies that apply here? Maybe we can use what someone else has already done to validate what we think we ought to be doing in this situation. And it's much easier to negotiate from that position if it's an objective standard and a proven way to do something. The best alternative to a negotiated agreement and a worst alternative to negotiated agreement are very important. You have to know going into any negotiation what your best alternative is, because that's going to dictate what you need to achieve from this negotiation. But you also need to know what your worst alternative is. What's the worst case scenario if this doesn't work out? So if it's a salary negotiation and you're going in to get a raise, well, if you have another job offer, that's your best alternative. By the way, it's not a good negotiating ploy to say you have another job offer. That's not the way to negotiate. But you know then what you can expect to get. If you have another offer at a higher salary, you can say, well, this is what I need to get. Otherwise, I know myself I can take that other offer. What's the worst alternative? Maybe that other offer falls through and you don't have any job at all. So what's your worst case scenario and what's your best alternative? And again, we'll look for win-win opportunities. The best negotiations are based on an ongoing relationship because there's an element of trust there. And most difficult negotiations are the result of poor communications and lack of trust. And I have to say that we lawyers are very good at destroying trust. Everything's got to be documented. Everything's got, if it's not in black and white, it doesn't exist. That's not the way the real world works. The real world works on the basis of trust. Billion-dollar deals have been done on a handshake, literally, because those people know each other, they trust each other, and they know that if they both say, yes, we agree, they'll make it happen. Lack of trust is what leads to those lose-lose situations because it's a downward spiral. And if you can't trust the other person, you've got very little leeway. So look at negotiation as a way of building trust. Look at it as a way to develop agreements on little things that can then lead to agreements on big things. Some people say, in a negotiation, we got to get all the issues out on the table. We've got to tackle the big problems first. And I agree with those that say, no, do it the other way. Tackle the little things first. Deal with the simple things, the things that are easy to agree on. And you develop momentum. You actually develop a feeling that you can trust the person. And that way, you can also decide whether your trust in the other party is justified or not. Do they do what they say they're going to do on those little things? Because if they don't on the little things, they probably won't on the big things. So I'm going to talk a little bit about negotiators. There's a lot of research in kind of game theory and negotiation theory. And one of the most interesting ones is on how to deal with a series of negotiations. And there's a lot of models for this. But the very simplest model is this. You have a series of agree-disagree negotiations. Cooperate or don't cooperate. And the way that it works is you have a simple scoring system where each of if you negotiate with the other person and you're successful and they're not, if you don't cooperate and they do, you win all the points. And say it's 3 points. But if you both cooperate, you get more points, say 4. So cooperating is more beneficial than not in total, but you split those points, 2 each. And if neither side cooperates, they both get 0. And there have been a huge number of models of every possible strategy. And in a series of negotiation, there's one strategy that wins every time. And that's called tit for tat. And the way that works is that you always start by being nice. You always start by cooperating. So in round 1, you cooperate, and either the other side does, and you each get 2 points, or the other side doesn't, and they get 3, and you don't get any, so you lose the first time round. In the next round, then you always retaliate. But after you do that, you always go back to cooperate again, so that you forgive their bad conduct in the next round. You show that you're serious, that you're not a walkover, that you don't just simply cooperate every time, time after time, no matter what they do. So you punish them for not being nice, but then you go back to being nice and generous. And generous just means you're willing to split the points. You're willing to share the benefits of the negotiation with them. And I've done a whole bunch of workshops where we've played this game in groups. And the tit-for-tat strategy always is the most successful. In a lot of the negotiating pairs, both of them will start off by cooperating, and then they'll just simply do the same thing round after round after round, and they'll split the points, and they'll get the maximum amount of points. In others, they start off the other way, trying to grab all the points, and they end up losing. And they can end up after 10 or 15 rounds of this game with 0. And a lot of them are in the middle. But this strategy is always the most successful. And there have been all kinds of computer simulations that have been done based on this. If you're really interested in game theory, you can read about this. But this is by far the best strategy for any kind of negotiation where there's a series of negotiations and you're going to do it over and over and over again. So you always cooperate unless you're provoked. You always retaliate. You cooperate the next time. And then the game has to go on for long enough for a pattern to emerge. And you have to be able to affect your opponent's behavior. And if you can do that, you'll be successful. In the games that I've done, the workshops, you're allowed to talk about what you're going to do, right? You're allowed to actually negotiate. So negotiation styles. You can focus on winning, or you can focus on relationships. This slide shows how that works. So content or relationship, which is more important? Well, they're both important. Some people have a very simple negotiation style. They just avoid negotiation at all costs. That's not very successful, usually. It doesn't help the relationship because the other person who needs to negotiate something, who needs to get an answer, is going to be very frustrated. And it doesn't really do anything for the content side either. So one alternative to that is to compete. And that's everybody's seen competitive negotiators. They've got to win every point. Everything is a deal breaker for them, and their only interest is in winning. Not very helpful, I guess, to a long-term relationship. On the other end of it, there are those who focus on the relationship to everything else, and they accommodate. Right? The customer is always right. Whatever you want, you ask, and I'll give it to you. That actually is an effective strategy in many situations. So retailers know that works. You can buy a lawnmower in the spring. You can return it in the fall. Get your money back, no questions asked. They probably won't even turn it over to see how much grass is caught in the blades. Why do they do that? Well, it's good for the customer relationship, and they figure, well, we may lose some money in the short run, but we'll gain in the long run. For most negotiations, it's not that effective. If you're always the one who's giving, at some point, that's going to get pretty old and you're going to stop doing that. So in the middle, there's compromise. And that's give and take. Right? We expect, in the negotiations, and Canadians are great at compromising. I mean, there's always some give and take. Right? But it's an effective approach, but it's not the most effective approach. I think the most effective approach is to collaborate. And that's back to the interest base. So we're not giving and taking. We're looking for ways where both can take a little more, where everybody gets more out of it. And that's by collaborating. And so in the long run, in an interest-based kind of negotiation, that is the most effective strategy. And so what I would suggest, and a lot of people say, is that should be your default strategy. That's not going to be the one that works in every situation. If you come up against the competitor who's only looking to score points and win every battle, collaborating isn't going to be successful with them. They're not interested in collaborating. So then you've got to be competitive. If you are lucky enough to find somebody who's just going to accommodate, well, maybe you don't have to collaborate. Maybe they're just willing to give you everything you want. But collaborating should be the default. So how do you deal with the difficult negotiations, the hard bargaining, the power-based negotiator who's going to get everything they possibly can from this situation? So these are the classic negotiating tactics to look out for, and we're all familiar with them. We've all seen them. The take it or leave it type approach to negotiating. So how do you deal with those? So these are some of the ways to respond. So extreme claims, those are the ones who start way out in left field because they know they're not going to get that demand. But they start with, demanding some outrageous amount and then make very tiny, tiny little concessions. So what do? Well, the tit-for-tat strategy works there. You make equally small concessions. Maybe you even make smaller concessions. But if they're willing to make bigger concessions, then you make bigger concessions. And then you get some momentum towards an agreement. The take it or leave it strategy is very simple. You don't. You make a counteroffer. You offer an alternative, and you justify it. You ask them to justify their position, and then you offer some alternative, or you just walk away. You call their bluff, and you leave it. The unreciprocated offers. That's where people say, you make an offer, and somebody says, "Oh, that's no good. Make a better offer." In the days of the real estate bidding wars, that was kind of the typical strategy. Somebody would put in an offer on the house, and the agent would go, "No, that's not going to do it. You better put in a better offer." Well, you're just negotiating against yourself. So look for a serious counteroffer. Threats, don't fall into the trap, I guess, is the first thing. Don't make a counter threat. Somebody says, well, if you don't play by my rules, I'm going to take all my marbles and go away. You don't then counter with, well, no, I'm going to take all the marbles. So, the way to get around having to make other threats is that you can challenge the underlying assumptions about what those threats are based on. Attacking alternatives, asking questions. If somebody says, well, that won't work, well, why? Why doesn't that work for you? What's wrong with that? And then you can start to dig deeper and find out what would work. Good cop, bad cop is a great negotiating strategy. Everyone who's bought a car knows how that works. You know, the salesman is your friend. No. You know, oh, my manager, well, I'd love to give you this deal, but my manager won't. Just, you know, first of all, to the extent you can, use the good cop to your advantage, but know that they're not really your friend. And where you can, negotiate with the boss, right? Let me talk to the manager. If you can't do this, I'll talk to someone who can. So common interest I've already talked about. In the interest of time, I think I'll skip over those. But they're, again, just to reinforce, they either want the same things, you want different things, but they don't conflict. And then in any negotiation, you come to the point where there are conflicting interests, usually over money. Someone has to pay more, someone gets less. And those are usually the last things to be resolved. In almost every negotiation, those are the things. But park those. Deal with the other things first, as I said before. Come back to those difficult ones because you may find ways around them. Communication, assertiveness, and empathy are important. To be an effective negotiator, you have to be both. You have to stand firm at some point. You have to be able to say, I hear what you're saying, and I understand that that's important to you, but I can't do that. So let's look for some other alternative. But acknowledge the validity of what other people are saying. Be empathetic, but stick to your guns. Understand that what you say is often less important than how you say it. Tone and body language are really important. Negotiating in person, face-to-face, is usually more effective than negotiating, over the phone. And you don't want to negotiate anything important by email. But when you're not sitting across from the person, it's a lot easier to say no. It's a lot easier to just dismiss things out of hand. So in-person negotiation is the most effective. I understand isn't the same thing as I agree. And it's important in negotiations to show that you understand. Yeah, I hear what you're saying, and but be aware of your own emotions and your emotional response, particularly when you're negotiating with somebody who's very aggressive and very demanding and very difficult, because you just get angry. You just want to kind of reach across the table and shake them, or worse. But that response, that adrenaline response, completely kills your ability to negotiate. You have to be able to separate that. So listening skills, active listening, just as I've described, of acknowledging other people's perspective, of showing that you understand what they're saying and you're listening to them, even if you're not agreeing with them. Flexibility. I've had so many people that I've negotiated with, they've got one thing in their mind, and that's the only thing they're focused on. And you may offer them something that's way better, but they don't see it because they're not open to it. And be pragmatic. If there's an acceptable option, alternative on the table, if there's a deal that's good enough, take it. I know, a lot of entrepreneurs, a lot of inventors that we've dealt with, they just can't take yes for an answer. There's always a better deal, and they end up with no deal at all because of that. So conflict resolution, and I'll spend just a couple minutes on this because I want to leave time for the Q&A after. You want to match the process to the business goals. And there's really two different ways to resolve conflicts. On the one side, litigation and arbitration, very little time or very little control, they're expensive, they're adversarial. Litigation's public, arbitration is the advantage of it's private. I'm an arbitrator, I do a fair bit of that work. And it is, that is a big advantage. It's confidential, it's private. Sometimes it's quicker and cheaper, but not always. It should be. Mediation is private. It is definitely quicker and cheaper, and you control the outcome, and that's the main difference. And facilitation is just a more informal way of mediating. So here's that slide that I had before, and you can see where mediation and facilitation are the kind of the collaborative, interest-based part of the scale. Litigation and arbitration are up there in the realm where it's rights-based and it's more expensive and less control over the outcome. So facilitation, very quickly, is informal. You control the process and the outcome. It is useful in many kinds of negotiations or many kinds of conflict situations, though, to bring a neutral into the process to guide the process and make sure that it's directed to address all of the issues and meet the needs of the parties. And often when people are negotiating, you need that kind of a neutral umpire, I guess you can call it. So problem solving and facilitated negotiations. In some of the big contracts we deal with, I do a lot of IT work, outsourcing and things like that. To have a facilitator when you have to renegotiate something where there's been problems is very useful. Mediation's more formal, but it is just a kind of facilitation, and the mediator guides the process. The mediator, and a lot of people don't understand between mediation and arbitration, the mediator doesn't make the decision. You're still in control of the decision and the outcome. You still decide whether you settle or not. And there's really two kinds of mediation: interest-based, where the mediator's a facilitator, and the evaluative. That's where often you get a retired judge, or there's court mediation, pretrial mediation in court cases. In those cases, the mediator is doesn't make a decision, but they tell you, this is how it's going to turn out. If you take this case forward, this is what your rights are, and this is what the outcome's likely to be. I think subject matter knowledge and process skills are the two most important things to look for if you're ever involved in this. Arbitration, it's adversarial. It's like going to court. It's less formal than going to court, but you have to follow certain procedural rules because you're going to get a binding outcome. Most of the time it's quicker and cheaper than litigation, but you can select somebody that's got particular expertise, and you can keep it private. The other thing about arbitration is if you're involved in any kind of international contracts, an arbitration decision is much easier to enforce around the world. If you go to court, well, who knows where you're going to end up and what their court system is like. But you have a very difficult time enforcing a award of, say, an Ontario court anywhere outside Ontario, and vice versa. Arbitration's much better from that perspective. And you want an arbitrator that's got some expertise in the area and is actually going to take control of the process, because that's what keeps the cost and time down. If the arbitrator makes it efficient, it'll be efficient. Other things that you can look at if you're involved in negotiating contracts and looking for dispute resolution processes, executive committees and escalation processes are very common. But also having a project umpire, a neutral who's involved in the project, who is there to deal with disputes along the way is a very useful process. There are some books, and won't dwell on this side, but anybody who's interested in learning more and developing negotiation skills, I'd recommend any of these books. And the ADR Institute of Ontario that I'm involved in has a lot of tools as well, and if you're looking for an arbitrator or mediator, that's a good place to go. And with that, I'm a little bit over time, but we should have time for questions, I hope.
Yes, definitely. Thanks very much, Michael.
Thank you.
I've got, that's a really cute dog over there, but I've got a couple questions from the webcast. One is about the role of emotions in negotiation. Is there ever a role in negotiations? For example, the question is, we're told we should keep emotions at bay. However, sometimes it is useful to show frustration when negotiations seem a dead end and nobody is happy. The question is, when do you balance the use of hiding and showing emotions? Is it ever a tactic?
It is a tactic if you do it consciously. It's a very effective tactic to blow your top and slam your book down or whatever and storm out of the room. It can change the whole dynamic. But you have to be very careful. You can probably only do that once, maybe twice, in long negotiation, and after that it doesn't work anymore. And you have to do it very, I guess, strategically. You can't just let your emotions go. I think it's okay to show your frustration. It's important to show your frustration, but you have to pick your spot and your time and make it effective.
And one question that came in earlier, after you had talked about power imbalances. This is coming from Sarah. She says, your statement about the power imbalances between the funder and the entrepreneur is often true. Do you have any concrete examples about how to de-escalate power differences between funders and entrepreneurs in order to negotiate and to continue to negotiate a contract between the parties?
Well, I think the important thing there is for the entrepreneur to focus on the value that they bring to the negotiation and to the relationship. One of the things about the balance between the funder and the entrepreneur is there are lots of people that have money. There's only one, the entrepreneur, that has this great idea. So in some ways, money's a lot easier. The money's a lot easier to replace than the entrepreneur or the entrepreneur, the startup team. And smart money recognizes that. So they won't overplay their hand. But having said that, the people that are writing the checks, have a lot of say, and so they're going to dictate a lot of the terms. But at some point, you just say no. I can find someone with money who's not going to, be as difficult to deal with.
And over there?
Thanks. Good evening. My name's Colin. I'm a tech investor and entrepreneur. I don't know why, but I tend to be attracted to somewhat controversial projects, so I've had more than my fair share of lawsuits. And in the past, by the time I'm served a suit, I just let a lawyer handle it. I don't engage in a very formal, drawn-out process. I'm about to start a new project, and I guarantee, mark my words, this year I will be sued again. Is it possible to slow things down? You're served the papers, generally without, I don't know who will sue me, but I know that I'm going to anger a bunch of companies. You're served the papers. Can you go and say, look, let's talk about this? Can you have a sort of back-channel dialogue at the point when you're formally sued? Or is it already too late?
No, you can always have a dialogue. And
would you advise it, or would you say, just let your lawyer handle it, do not talk to them, do not?
I have a conflict of interest here. As a lawyer, I would love to have you for a client and keep collecting your money. As a business person, I want to try to see if I can do a deal with whoever it is that's suing me. First of all, you need to know why they're suing, and what the alternatives are. I mean, again, back to what's the best alternative, and what's the worst alternative. So, maybe the best alternative is just draw the lawsuit out as long as you can and hope it goes away. But maybe there's a better alternative.
All right. Thank you very much.
Thanks.
That's cool.
So, another question? Yes.
Hi, thanks for the great talk. So my question on negotiation is, let's say there's two parties at the negotiating table, party A and B. Party A makes an offer, but it's based on, but their basis for making the offer, or the reasons that they put forward for making the offer, are dishonest or lies, and party B is aware of this. What would you suggest party B do in this case? What kind of offer should they put forward?
First of all, I would challenge the basis of the offer, of the first offer. I think it probably, depending on how much information you're willing to disclose, it may be helpful to let them know that they're lying. Because then they're on the defensive. They lose their leverage. You may want to wait and see how it plays out before you let them know that you know. And that's just a negotiating strategy, how much you disclose, how quickly. But if you know that they're lying, that puts a lot of leverage in your hands if you're able to use it. The other answer to that is, if they're that dishonest, why do you want to deal with them at all? So at that point, maybe you just say, well, I know that you're lying and I'm not interested in dealing with you. But there may be other reasons why you have to, or why you want to. But if you call them on it, you may be able to change how they behave.
Thank you.
Welcome.
Okay, we'll take two more questions.
Good evening. I'm Colleen from Bliss Escape. I just wanted to ask your advice. I was recently listening to a Seth Godin podcast from his Startup School series, and he suggested that when you're putting together a contract, that you should put in a clause about mediation as opposed to arbitration or suing each other.
Yeah.
And I just wondered if you could comment about that. Is that a good way to go for startups? I think it might be a way to save a lot of money.
Yeah, I would agree with that. There are some people that say, well, you don't need to put mediation in a contract because it's voluntary. You can't force people to mediate, and you can't force people to come to a settlement. I think you should put it in the contract because it acts kind of like a circuit breaker. It sets an expectation that you are going to sit down and talk first, and if you don't come to an agreement, you will bring in a neutral facilitator or mediator to try to help you resolve it. And nobody feels like they're showing any sign of weakness by asking for mediation, because the contract says we have to do it, so we'll do it. But having done it, having come to the table with a mediator, you usually can come to some sort of settlement. Half the battle is getting people to the table. So if it's not in the contract, probably they won't do it for whatever reason. And if it's in there, they will.
Thanks.
You made a comment I would like for you to expand on, which seems to go against popular wisdom, that you never take the first offer that is given to you. And when you were talking about pragmatism, you seem to say that if the first offer is good and it meets your interests, you take it because you consider taking it because you don't know what might happen if you don't. What do you do if you get that first offer that's genuinely meets your interests and the other person's interests? Do you make a show and try to get something more, or do you just accept it and hope it's that easy next time?
It never hurts to ask for more. It doesn't hurt to ask. So taking the first offer, no. I mean, that's probably taking pragmatism a little, one step too far. But having asked, if the answer is no, we don't have a better offer, and the offer you've got is good enough, then yes, then you can take it. But no, I wouldn't say take the first offer. The first offer is never the best offer. There's always some room to negotiate. But be realistic about the expectations. Yeah, thanks. One more?
Yeah, one more.
Okay.
Hi. Can you speak a little bit about when you should hide your cards or reveal them, and how to identify what the other person's objectives are and their upper limits?
Identifying first. Ask questions. Ask a lot of questions. The best negotiators spend most of their time asking questions, trying to determine what's important to the other side. And having determined what's important, then what's really important. And getting information, I think, is the key to negotiation. Often, to get information, you have to give information. So if you're too closed with the information, if you hide all the cards, you're not going to get any meaningful information back. So you've got to be willing to share information that you're willing to share, that isn't going to hurt you, that you think is going to benefit you, in order to get valuable information in return. But the real value in that exchange, that dialogue, is the information you get. So you should spend a lot more time listening than you do talking.
Thank you.
Well,
Thanks.
with that, we will close off. Thanks very much, Michael, for your very practical and relevant presentation.
Thanks.